record the public disclaimer.
Okay, we'll do. And just one quick reminder, if you're not speaking, if you will just try to mute yourself, it will help with the background noise. Okay, notice of the August 12th, 2020 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 30th, 2019. Additionally, this month's agenda has been posted on the website since Thursday, August 6th, 2020.
And now, if you'll call the roll.
Okay, will do. Commissioner Joe Begley.
Here.
Commissioner Jeff Diaz. Commissioner Jeff Diaz. I'll come back to Jeff. Vice Chair Marcia Franks.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith. Commissioner Stacy Torbett.
Here.
Chairman John Grease.
Here.
Let's circle back to Commissioner Jeff Diaz. Okay, you have a quorum.
Thank you, Caitlin. At this time, I'd like to ask Commissioner Stacy Torbett to lead us in invocation. And following that, if you all will stand, she will also lead us in the pledge to the flag. Stacy.
Thanks. Dear Heavenly Father, I just thank you for the ability to meet today. I thank you for technology so that we can still meet despite what's going on. I ask that you be with us during this meeting. Also ask that you be with the commissioners that have lost parents in the last couple of weeks and just give them the peace that passes all understanding and help us to honor you in our words and our actions. In Jesus' name, amen. I have a flag.
All right.
All right.
Because I feel so silly standing up and not looking at anything. All right, there's the flag. I pledge allegiance
To the flag
in the
of
United
the
States
United States of America
and to
and to the republic for which it stands, one nation,
Under God,
indivisible,
for all.
with liberty and justice
for all.
for all. Thank you, Stacy. At this point, we're required to read into the record a statement of necessity, and Anna Matlock will do us that favor.
This is a telephonic scheduled meeting of the Tennessee Real Estate Commission. Notice of this meeting was posted to the Commission's website on Thursday, August 6, 2020. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated Section 8-44-108B2, which states as a physical quorum is not present at the location of a meeting of a governing body, and in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of members by electronic or other means of communication is necessary. As stated, this is a previously scheduled meeting of the Tennessee Real Estate Commission that is now being held via WebEx. The purpose of this meeting with members attending by WebEx is to conduct regular business of the Commission, including but not limited to the Education Report, Executive Director's Report, and complaints. Furthermore, it is necessary for this meeting to be held by teleconference in accordance with in accordance with Executive Order Number 16 issued by Governor Bill Lee on March 20th, 2020, further extended by Executive Order Number 51 issued on June 29th, 2020, to ensure government continues to function open and transparently during the COVID-19 emergency, while taking appropriate measures to protect the health and safety of citizens and government officials. Voting will be conducted by roll call.
All right, Commissioners, we have to adopt this statement of necessity. So Caitlin will read your name, and if you're in favor of adopting the statement of necessity, you'll vote yes. If you're opposed, you'll vote no. Ms. Matlock, Ms. Maxwell.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz, Vice Chair Marcia Franks, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, so the statement of necessity has been approved and passed by commission. At this point, we'll continue on with the agenda, which is first to approve today's agenda. Is there a motion or are there additions or deletions commissioners would like to offer?
Move to approve.
A second.
All right, the motion by Ms. Frank, seconded by Mr. Begley, is to approve the agenda as presented. Is there discussion? All right, I hear none. Let's vote. Those in favor of the motion to approve the agenda, vote aye.
Aye.
Those opposed, no. The agenda
Aye.
is approved. Oh, we
Might
have
have to
to
do a roll
do
call.
my fault. We have to roll call. Thank you.
Yeah. It was a nice try.
I'll keep trying if I can.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Whoops. Yes. All right, the agenda is approved. Next up is to approve last month's minutes as they were presented to us electronically. Is there a motion or is there discussion on those minutes?
I move to approve.
Second.
All right, motion by Steve Gwynn, second by Marshall Franks to approve last month's minutes. Discussion. All right, then let's vote. Those in favor of the motion. Oh, shoot. Caitlin, call the roll.
Commissioner Joe Begley,
Aye. Keep trying.
Commissioner Jeff Diaz, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, the minutes are approved. Included in those minutes was a deferral for 30 days of a discussion about medical waiver request. So let's move to that at this point. Jeffrey Abbott. Caitlin.
So the commission had asked that a letter to the commission be included with the medical waiver. So in the email with your documents, you now have an overview of the medical waiver, his letter to the commission, and then a doctor's statement detailing why he's making the request. He has complied with all education and has current E&O and has paid the actual renewal fee without any late penalties at this point.
Commissioners, thoughts?
I'd like to make a motion that we approve the Abbott request.
Second.
Okay, I didn't hear who the second was.
It was John Moffett.
Okay,
John.
perfect. Thank you, John. So the motion on the floor offered by Marcia Franks and seconded by John Moffett, if approved, would grant the waiver requested by Jeffrey Abbott. Discussion. All right, let's vote. If you're in favor of granting the waiver, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Okay, Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. So Jeffrey Abbott's request for medical waiver is granted. At this point, I noticed that DJ Ferris has joined the conference. DJ, we'd like for you to, here's the problem. DJ has not received his oath of office yet, so he's not allowed to vote, although he's a commissioner as far as I'm concerned. But we asked him to come on anyhow so we could see what he looks like and see if he wants to tell us anything about himself. DJ, are you there? DJ. We'll come back looking for you in a little bit. Let's move on to the Education Director's report. Ross, are you on?
Hello, Mr. Chairman, members of the commission.
Hey, Ross White, good to see you.
Good to see you. Good to see everybody. It's a nice day inside today. Yeah, I was one of those folks that went in once in the last 4 or 5 months. So as Caitlin was telling you about, and yeah, so that's what we do now. We stay safe, we clean up our areas and clean up before we leave. So there you go. But I'm at home today, as most of us are. Yes. So I'd like to present to you this morning the education agenda for today, August 12th, 2020. First of all, the agenda and report that I have reviewed all the providers, instructors, and courses for today, A1 through A36. I present that for your approval.
All right, the executive director, the education director has recommended that this commission approve courses A1 through A36. Does any commissioner wish to pull a particular course out before we vote on the balance? If not, is there a motion to accept the education director's recommendation and approve courses A1 through A36?
I'll make a motion.
Thank you, Joe. Is there a second?
Second.
Seconded by Marcia. So the motion on the floor is to approve the education director's recommendation that we approve courses A1 through A36. If you're in favor of that, you'll vote yes. If you're opposed, you'll vote no when Caitlin calls your name. Ms. Maxwell.
Okay. Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, that motion passes. Now we're on to instructors. Ross, you've got 5 instructors you're recommending we approve to teach.
That's correct, Mr. Chairman. They should be on your iPads there.
If we have iPads.
Yeah, if you had them up. I assume they were sent to you, but yes, there are 5 to approve this morning on 2 forms.
Commissioners?
Move to approve.
Second. Second.
Who was my second?
Joe.
Joe.
Oh, thank you. So the motion is to accept Education Director's recommendation to approve 5 instructors noted on the material that was sent to you. Is there discussion? If not, let's vote. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. So that passes unanimously or with 7 votes. Ross, do you have anything else education-wise you want to talk to us about today?
Thank you, Mr. Chairman. Yes, I do. Have we reached a point where we're busily working now on the renewals for the next education cycle, which is 2021, 2022. And we're moving along with that quite nicely. The renewal period begins September 1st, and we've gotten out preliminary notices to the providers about their courses, and we'll continue on with that process. But secondly, during this period of time, and for the provider's benefit, we have the adoption of the core, the 6-hour core course. And so that should be on your agenda listed there with the 2019-2020 topics in the outline. My suggestion to the commission, and I have run this by Anna and legal, and Caitlin and I have discussed it, but I think that you might want to consider during this period of time, and since we've had no relevant changes to rules and laws and policies, that we just accept this 2019-2020 topic outline for the next 2 years. We go on and adopt it as is, and I think that would be a good idea, certainly during this period of time we're in, and that will give the providers time to put their courses together, changing the dates and what have you for the next 2-year window. They have to send these in to be approved, each provider that wants to teach this next cycle of the course.
Caitlin, do you have something?
Nope.
Do you agree with Ross's recommendation? We approve it as we approved for 2019, 2020?
I do. I think that it would be helpful to the providers, and also, at least when Ross and I were discussing, there were no other pressing topics that we felt like potentially needed to be added. Obviously, you guys are the subject matter experts, so if you feel differently, we're all ears, but we did not see anything else that needed to be added to the list that was pressing.
Okay, Commissioners, Marcia?
Yes, so it's not for 2019 to 2020. This would be for 2020 to 2022. Is that what you're saying?
Yes, ma'am. Commissioner, that's what we're doing. We're actually taking the topics that have existed that will be good through the end of this year, 2019, 2020, and then approving them for another 2-year licensing cycle.
So in the future, if something, we now know that lots of things happen that we do not expect. Would we be able to add something to it, or we've never done 2 years at a time. We've never approved it 2 years at a time. It's always been 1 year. So I'm just wondering, what if there's something we need to add to it, that a year from now, for some reason.
To be clear, the commission adopts these every 2 years for the next 2-year period.
Okay.
But secondly, what probably would be in order, and we haven't, we had some plans on getting a provider conference together as we did last year, We certainly hadn't been able to do that yet, but I think that would be a good idea to get their needs and suggestions and offers of perhaps topics and outline elements that might be important. But at this point, given that we haven't had a significant rule, law, or policy change, that's why I'm saying, and two, to provide the providers time to get themselves ready. It will help them, I think, to put this together for the next 2 years. That's why we're suggesting it. And this is a one-off. It hadn't happened this way before. You are right, but it's a 2-year window.
And you wouldn't want to necessarily change it just because providers will organize their course and send that to the commission for approval. So once it's out there, they create their course based on the topics that the commission approves.
That's correct.
Okay, Marcia, with that information, are you ready to make a motion to use the same core curriculum in 2021-22 as we did in 19 and 20?
Yes, so moved.
Seconded by John Moffitt. Thank you. Discussion? All right, then let's vote. Those in favor of that motion will vote yes when Caitlin calls roll, and no if you're not.
Okay, Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz, Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffitt,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. And Ross, to be clear, what we just voted on is the commercial core class and the residential, right?
That is correct. Yep, both
Okay.
residential and commercial.
All right, thank you. What else do you have?
That's all I have, Mr. Chairman, members of the commission. I appreciate it.
Thank you, Ross.
Thank
Are you
you,
wearing a
Ross.
tie today?
Pardon?
Are you wearing a tie?
No, I've
Okay,
got
just
my
checking. Just
little
checking.
bolo on here.
All right, just checking. Hey, DJ. DJ. All right, I'll check back. Executive Director's Report. Caitlin?
Okay, so primarily you'll see that on my report, our numbers are getting back to where they were sort of pre-PSI closing. So we're definitely seeing an increase in our applications and, things slightly getting back to normal as far as testing goes. I did want to mention, you will see in the email that I included a reciprocal agreement that was between Marcia.
Can we go back to the PSI?
Yes.
So I'm wondering, I had one new person who went to Bowling Green for their test, and now I have 2 more that have to wait 2 months or go to Bowling Green. So I'm wondering how PSI, are they going to add more places, or what are they doing to take care of the backlog?
So I had a call with PSI last week. So I guess I shouldn't have said things are back to normal. I guess our numbers are getting more back to normal. But as far as PSI goes, we have been working with them because we have been having a lot of people have issues with getting tested timely. We've had issues with people getting a timely response. And we've had issues with people getting last minute cancellations. And so they did address all of that on their call. They have done a couple changes to their customer service. We now have a designated line that will just be for real estate. So that will hopefully help with the wait time. And then they have also changed the way in which they're responding to emails. And they've now put in a requirement to respond within 24 hours. So hopefully that will help with the customer service piece. They are looking to add more testing spots. They're looking to add more locations. And they're looking to make their hours longer, as well as potentially looking into being open on Sundays. They're also going to start sending me a report so I have a screenshot of what the availability is across the state. And then in addition, I guess some of the issues that they mentioned on the phone is historically they have used colleges and schools as testing locations, which is part of the issue that they've been running into is that they are subject to that college and that school schedule. So a lot of those locations that they previously had available are no longer available on the same basis. In addition, one of the things that they're running into is they're subject to proctor availability. So that hiring process and getting people to work has been a little bit difficult. I had one candidate that emailed me and was very upset to be canceled last minute. And I know PSI is trying to avoid that, but in that instance, they told me that the proctor had called out for that day. So those are some of the obstacles that they're currently experiencing. But they are looking to add testing spots, make their hours longer, and then also looking into adding spots on Sunday.
So, Kaylin, I would say to that that's the same report they gave last month, and they've not done anything to change that. I'm very unhappy with PSI. We really need them to make this happen, not just we're trying, because I know for people like me, when I take a 2-week class, I want to take that test immediately because somehow it drifts out of my brain. And if I've got to wait 2 months, and these students they don't even know it. So they take their classes and then they want to take the test immediately, just like I would. And to have to wait 2 months, that's just not acceptable. It's not acceptable at all. So they're going to have to do something, and they need to prove it to us by this time next month. Or, there's other providers that we can use if they can't make it happen. I'm just very upset with them that it's not fair that people are having to wait 2 months or have to drive to another state because they've got openings in other states, but they don't in Tennessee. So please just let them know that.
Yes, I will. The only other thing I'll mention is they've added a full team that is working to get our test available online. So they are working to do that as soon as possible.
That'd be great.
So, any other questions about PSI?
Let's go back to Kentucky.
Okay. So you will see that on your email with your documents was also an agreement between Kentucky and Ohio. So just a little bit of background on that. The Kentucky director reached out to me earlier this year, and then they've had some changeover, and they've had a new director start within the last couple of months. Over the last couple of months, he has been reaching out to me about doing a reciprocal agreement between Kentucky and Tennessee. And from those conversations and from other correspondence with Tennessee licensees looking to get licensed in Kentucky, they do not have the same statutory authority that we have that allows us to look at candidates' experience from that state and allow for equivalency if their requirements meet or exceed ours. And the only way for us to do that with them would be through a reciprocal agreement. So over the last couple months, I've been getting a lot of complaints from Tennessee licensees that are looking to get licensed in Kentucky and are not able to use any of their experience or education from Tennessee. So what you will see is a sample of the agreement that they did with Ohio. We are looking to do something similar. At this point, it's really only negatively affecting Tennessee licensees. Licensees that come in from Kentucky are able to use their experience in education, assuming that it meets or exceeds ours, which Kentucky has as much education as us, if not more. Their pre-licensing for affiliate brokers is a 96-hour course compared to our 90. And then their broker is a total, let me pull this up. I believe it's 336. Yes, 336. And 48 of those hours have to be in broker management. So my request to the commission would be that myself and legal could work with Kentucky on a similar agreement to allow Tennessee licensees to get credit for their experience in education from Tennessee.
Marcia,
Caitlin, at this point, it appears that that all we would be able to do is this allows Kentucky people to come and sell in the state of Tennessee. So would they still be bound by the Tennessee law, or would they be bound by Kentucky law when they're doing business in the state of Tennessee?
So this really would not change anything for Tennessee because in the agreement, it requires that they get a license certification from their state that they submit to us, which is what they currently do if they want to get licensed in Tennessee. And it also requires that they take our state portion of our exam, which is also in line with what they currently do. So to be honest, this will not change how we license Kentucky agents. The agreement, pretty much as written, is how we already operate. What it will change is it will allow Tennessee licensees to be able to get credit for the education and experience they have from their Tennessee license.
Okay, so I can tell you there's there at Arillo, their executive director from Ohio, Ann Pettit, when she was president last year, started a task force looking at this, and she's very pro having reciprocity with everyone. And so that's why I see that with Kentucky, because that was an Ohio border state. I think, though, that we need to give a lot of attention to this and make a good decision about it. I think we need more information about it, and we need to make sure that the playing field is level, because this will open the door to not just states that connect to Tennessee, but it also would connect California, Washington, Oregon. That's where I see things are heading. So we, as commissioners in Tennessee, we need to decide what direction we want that to take. The other thing too is, would this have to be something we do by rule, or is it statute that we have no reciprocity?
So we have the statute, I'll read it to you. That this is the statute that we currently use. We currently use the statute that says it's under 6213-314 under reciprocity. And it says the applicant has, the commission may issue the appropriate license to a non-resident applicant if the applicant meets or exceeds each of the qualifications for licensure in this state. So Kentucky does not have that statute that we have. Theirs requires a reciprocal agreement. The commission also has the authority under that same section, under 6213-314C, and it says, notwithstanding any law to the contrary, the Tennessee Real Estate Commission has the authority to enter into reciprocity agreements with another state if in the judgment of the commission that state has meaningful requirements for licensure. The reciprocity agreement may authorize the licensure of the Tennessee licensees in that state and for the licensure of the licensees of that state in this state.
So this is something that would be brought back to us for us to have a vote on in the event that we do open up to Kentucky. Is that correct?
Yes, although I do want to make it clear that this agreement as written is the same way that we are already licensing Kentucky licenses into Tennessee.
So there's no reason to sign an agreement then, is there?
There is for our licensees to be able to get licensed in Kentucky. Right now, if you wanted to go to Kentucky, for example, you would have to start from scratch. It wouldn't matter that you have, the number of years of experience that you have. You would have to start from square one. Whereas if we did an agreement, Kentucky would give you that experience and education that you've taken in Tennessee and give you credit for that. So right now, really the only negatively impacted licensees are Tennessee licensees. And this is something I should have mentioned that Tennessee Realtors is also in support of. We sent in one of the email communications a letter from them because I believe that they have also been getting complaints from Tennessee licensees about this, as have we, where, somebody that's been a principal broker in our state for years cannot go work in Kentucky without starting from the beginning.
We just need a level playing field, however it goes.
So, Caitlin, so, I don't like a lot about this agreement between Ohio and Kentucky, but in particular, paragraph 2.4. Can you look at that for a second?
Yes.
So let me ask you, if Kentucky company wants to work in Tennessee, do they have to have an active physical location in the state of Tennessee?
In our state, they do not. They have to be affiliated with a firm that is licensed through the Tennessee Real Estate Commission.
So 2.4 says there shall be required to maintain an active place of business in the reciprocal state. It goes on to say the place of business shall be a physical location at which an investigator from the reciprocal state may enter and perform such investigations. We don't have anything like that required of Kentucky, do we?
I just want to chime in real quickly. So this is just a sample agreement between Ohio and Kentucky. Our agreement would mirror our requirements from the rules and statutes. So that would obviously be something that we would change.
Well, that's good, because I thought our statement say this pretty much reflected what we're doing now, and I don't think we're doing that at this point.
Not this particular agreement. We're not doing this. We're just she's talking about like licensing in general when a Kentucky licensee is to apply here in Tennessee. So that's what we're talking about. This is just a sample. We wanted you guys to see a copy of what it would look like. And obviously we'll make the necessary changes to make sure that it comports with our statutes and rules.
So the letter from the Tennessee Realtors that was written by its executive director, do you think it endorsed the concept of getting an agreement together, or was it endorsing the conditions spelled out in this document?
It was, I don't want to speak on their behalf, but I know that they're in favor of us creating our own reciprocal agreement.
And that's good. I think I'm in favor of that too, but not with conditions that are spelled out in the sample. To Anna's point and to Marcia's point, whatever you guys come up with that reflects our statutes and rules, it needs to come back to us to let us take a look at.
Okay. So we can bring it back in September.
And I would like for it to be our agreement, not them send us an agreement and we sign up on it. I know there has to be some negotiating done, but maybe we need to let them, if we're going to go that route, what do we want in the agreement? What do we as Tennessee commissioners want in that agreement?
Okay, other discussion on the proposed Kentucky reciprocal agreement?
Mr. Chairman,
Yes, Steve.
what other reciprocal agreements do we have with other states? I'm wondering, just as a personal piece of knowledge, do we have reciprocal agreements with others like Mississippi and Arkansas, surrounding states that abut Tennessee, or will this be the first, or what's our situation there?
So there have historically been agreements. I have seen them probably 2 directors ago. I don't know the history of why those went away. Our statute allows for out-of-state licensees to come here. They provide a license certification that we review. They provide any state that they've been licensed, they provide that license certification. That tells us when they were first licensed, how long they've been licensed, if there was any gaps in their license. It tells us if they have any discipline on their license. It really gives a full picture of their history as well as any education that they've taken. They send that to us, we review it, we determine which of those requirements are equal or greater to our requirements. And then from there, everybody has to take our state law exam. That's not waived for any out-of-state person. The national exam can be waived if they've taken the same equivalent national exam. And then assuming that their pre-licensing requirements are equal or greater to ours, then we can give some waiver there. And then once licensed, they have to meet all of our continuing education requirements.
So we don't have any reciprocal agreements with any other states. Is that what you're saying?
That's what I'm saying. Our statute doesn't require the need for it. Kentucky does not have what we have. So.
But does that mean other states that abut us have that, meaning Mississippi and Alabama and North Carolina and all the other states, or what?
I can't speak to every state, but I know that Mississippi has something similar, I believe, to what we have. But part of the reason this came about is we were starting to hear from our licensees that were complaining going to Kentucky and not being able to use any of their experience or the education that they've taken here. So Kentucky does not have that statutory authority that we have to allow.
Okay. So this is more an anomaly of Kentucky than it is the standard that maybe with Mississippi or Alabama or North Carolina or the other states that abut Tennessee, where we have agents, licensees in Tennessee going into those other states, and it's not a problem. It's a problem with Kentucky. That's what you're saying.
Yes, yes.
Okay.
Other comments or questions about the Kentucky Reciprocal Agreement proposal? If not, hey, DJ.
Yes, sir.
All right. Welcome.
Thank you, Chairman.
Would you care to tell a little bit about yourself to the people present on this conference call?
Yes, thank you for the opportunity. Am I too loud?
You're perfect.
Okay. Appreciate you bearing with me as I get set up this morning. I am very humbled to be a part of this group and look forward to serving alongside each of you and getting to know you further. I'm a native to Tennessee, grew up in Wilson County, and moved to Nashville to attend Lipscomb University and live here in Oak Hill with my wife, Kella, and our 2 children. I've worked in real estate since 2007 when I was a student at Lipscomb. I fortunately came by way of the late Emil Mungen. And Emil early on impressed me with his devotion to the industry, to his colleagues, and took a chance on a young kid who barely had enough sense to get in out of the rain. And so now I'm very, very honored to kind of serve in a way that has been offered me. And it was, I think, from him being my first broker, it was impressed upon me how good that would be to serve. So, yeah, I've had several experiences from Clark to Worth Properties, different brokers here in town, and nothing but good experiences, and serve our citizens of Tennessee.
Great. You know that you should be voting today, but your oath of office didn't arrive in the mail, which might speak to future absentee ballot problems. I don't know. But in any case, we do look forward to you fully participating with us next month. And I hope you'll stay with us and watch how this consent agenda goes. It'll move pretty quickly today. It'll be unusually quick, I think. But you'll get to see how the process works. And we're thrilled you're with us.
Thank you. Already, just listening to the content, I'm very excited to be a part of this and learn a lot and be further engaged with the state. So thank you.
And you're right about Emil. He's a great guy. All right. Mark Green.
Mr. Chairman.
Now, Mark, let me just introduce you. You're the Deputy Chief Counsel, which means you're one of the top dogs in the legal end of the Department of Commerce and Insurance. Is that correct?
I think Dawn would be apt description.
Well, we're glad you're with us. All right. Again, if you don't have your computer muted while Mark's talking, it might be helpful. Okay, Mark. Any opening comments?
Thank you, Mr. Chairman. Yes. First of all, it's a pleasure to be with you today. I decided to do this myself, and I'd like to start off with an apology. My office made an error last week in having a legal report prepared and to give to Caitlin at its due date. We currently are short-staffed, and some decisions were made that were not the correct decisions. We tried to get that corrected and get a legal report together. I decided that I would come and take full responsibility for that mistake happening, and present the legal report that we did get prepared by Friday afternoon. And so and also answer any questions. It's been a while since I have appeared before you. There's a lot of new folks on here that I have not met. In fact, I think it's getting to where I know fewer personally of you than I don't. So I thought it would be a good opportunity for me to come in and introduce myself and offer that explanation and apology and take responsibility for the legal report that we did have prepared. So that is what has led me here today, Mr. Chairman. So I'm honored to be here and process that occurred.
So, Mark, most commissioners don't know that you started where Anna is right now. Is that about right?
That is exactly correct.
And how long ago was that?
That was in 2011. That was all. And then I was chief counsel and kept track as part of my responsibilities. And then I was promoted to deputy general counsel, where I've been. So TREC has always been one of the programs that I've always been the most involved in, and certainly not necessarily in presence before you, but obviously in discussions about anything that goes on that deals with your area.
So let me say, commissioners, Mark is really a good guy, and he's easy to mess with. And sometimes he shaves and sometimes he doesn't. But you need to get to know him, because if you ever have an issue, he's very approachable, easy to reach. And I appreciate your remarks about the legal report. I'm singing your praises, but I might want to argue with several of your decisions or recommendations. So unless, all right, commissioners, any other questions or comments from Mark before we get started? If not, our process typically, Mark, is to read all the case numbers into the record and then see if commissioners want to pull any of those out, at which point those are pulled out and we'll take a motion to approve the bulk of the cases as you recommended. So if you will read the case numbers into the record, we'll get started.
Number 1, 2002-00-47481. Number 2, 2002-00-22941. Number 3, 2002-00-26551.
Hold on one second.
Joe?
John.
Yes.
Yeah. I've got 2020 on these. Does that make a difference? I don't have 2002.
Mark?
Is that,
Oh,
matter?
yeah, I'm sorry. I misstated that, Commissioner. You're exactly right. Let me.
I don't know if it
They're not
matters.
2000. No, it's not 2000. 02-00-47481 would be the first one.
Hey, Mark.
Yes.
Do you think we could stipulate that each of these cases begins with 2020 and skip that part?
Absolutely.
All right. Let's do that.
All right. Let's see. What was I?
Go to number 3.
Okay. Number 3. 2020-0251. Number 4, 220-026781. Number 5, 2020-035391. 2020-02-6931. Number 7, 202-003-1391. Number 8, 202-00-201. Number 9, 2020-03-9321. Two zero two zero 0405 Number 11, 2020-03-0701. Number 12, 2020-03-0711. Number 13, 2020-03-3171. Number 2020-03-3161. Number 15, 2020-03-2191. Number 16, 2020-03-181. Number 17, 2020-026501. Two zero 0391. Number 19, 2020-0391. Number 20, 2020-03-2771. Number 20, 2020-02-9161. Number 20, 2020-03-1561.
Thank you.
Is that the number you have, Mr. Chairman, on the report?
That's it. 22 recommendations. Now, before we take a motion on those cases, are there cases that commissioners would like pulled out to discuss individually? Marcia? I'll come back to Marcia. Are other commissioners cases you'd like pulled out? Okay. I've got a few. And I have sent these. I think, Mark, you received my comments. So my goal here is to have as few votes as possible. Okay. So regarding cases 5 and 6, the cases mention a designated managing broker. which I don't think
Yes.
I've ever heard of. Can you tell me what that is?
That's internal nomenclature. That company has principal brokers at each, but they call them there's a principal broker of the company, but at each location they have a principal broker, and they call them the managing broker. That's internal, but those people are listed for that location as the principal brokers. So when the summary was written up, it was using the internal nomenclature of the company when it should have said the principal broker at that location. There's only one principal broker, and that's the one at the location.
The way I read it, it looked like there was a principal broker at each branch, but there was somebody above that principal broker who was in charge of reviewing documents. Is that, did I have that right?
Yeah. Well, there is an individual. This is their practice. This company used to have locations not in comport with the statute. They didn't have a principal broker at each location. They now do have a principal broker at each location, but there still remains a principal broker that is over those principal brokers, the owner, the managing partner or managing person. So each location does have a principal broker, but there is somebody in that company. And Anna, you may have some insight on this as well, and please feel free to chime in as to how they're set up. I think they're in line with the statute. They just have a layer of management that's above the principal brokers.
Correct. So Martha's right. Their principal broker is a person. They follow the statutes just as written. It's just a matter of how this summary was written, how it was responded to. So this is their internal setup, how they work. But their principal broker has the same duties and responsibilities as a principal broker in statute.
Is principal broker defined in the statute?
A principal broker is not, the specific term is not defined, but we have what their duties are listed as, supervision terms.
But in managing broker defined, but not principal broker. This is unrelated to the cases, but we call people principal brokers, but I don't know that the statute ever says the person in charge and taking responsibility is called the principal broker. Could be wrong. That's for another day. We'll let it go. Okay. So I'm okay with that explanation. I'm going to go ahead and on number 7, Mark, this is not a criticism, but traditionally, and I know you were working fast and hard, legal, when they make a recommendation, gives us some rationale for what their decision is. And there's at least a number of cases, and maybe including number 7, where there's just a recommendation. So you state a few facts and close. I don't think you'll be doing this next month, but if you instruct staff, it'll be helpful for us to have legal's rationale for why they make the recommendation.
I totally understand. Thank you, and I will make sure that happens.
Okay. With that said, I'd like to pull cases 9, 10, 16, and 17 from the consent agenda.
Okay.
Marcia?
Yes.
Do you
Yes,
have
sir.
cases you'd like pulled?
Just number 17.
All right. Other commissioners?
Hey, John, just to clarify, I was thinking you had pulled 7 and not 9.
No, I was going to pull 7, which was basically a case we didn't need to be hearing, in my opinion. But the recommendation is right. We still want to close it.
Okay, so 9, 10, 16, and then 17.
Correct. Okay, if there are no other cases that commissioners would like pulled, is there a motion to accept council's recommendation on cases 1 through 22, with the exception of cases 9, 10, 16, and 17.
Motion to approve.
Thank you, Stacy. Is there a second?
Second.
Was that, who was it?
Second.
Marcia? Joe, okay. All right, so the motion, if you agree that all cases should be handled as council recommendation, cases 1 through 22, with the exception of cases 9, 10, 16, and 17, you'll vote yes when your name is called. If you're opposed, you'll vote no. Caitlin?
Okay, Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz, Commissioner Marcia Frank,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, that motion passes. Now on to case number 9. This is a short case. Mark, you want to just give us quick, you can read it probably, you can quicker, you can summarize it.
Yeah. This is a matter where complaint alleged the respondent is selling 8 homes owned by other individuals in Tennessee and using a website with a different company name, also not licensed, to market and sell homes. The complaint alleges unlicensed real estate activity by the respondents. The respondents are unlicensed. They are offering these homes for sale, and they failed to give a response. So the recommendation was $1,000 civil penalty for unlicensed activity.
And so in my opinion, when I read this, I didn't know there was proof that they weren't licensed, but there was proof that they did not respond. So it's a minor point, but that's why I pulled this.
Well, and let me, because they're unlicensed, I don't think we can hit them with failure to respond, because that obligation is to licensees, not to unlicensees.
I got it. Okay, so I'm good with that. Is there a motion to approve council's recommendation?
John,
Yes.
John. Okay, so there were 8 properties, not just one.
Right.
I'm just wondering, we have the ability to find them on 8 different occurrences if we know for sure there were 8 homes. And a lot of times people who are unlicensed, $1,000 means nothing to them when they're making real estate commissions on 8 homes. So I'm thinking that we should charge them more than $1,000 because there were 8 different properties. Do we know there were 8?
Anna, can you look and see if that is in the file?
Yes, I will do that.
Thank you. And John, for the new members, I would say that the maximum fine is $1,000, but we can do it per day and we can do it per occurrence. So that's where I'm headed with this.
And for the new members, we don't call it a fine. We call it a civil penalty.
Right. Right.
So much more civilized.
Yes.
So, question.
Go, Steve.
What would be the maximum then that we, per day, on how you figure out what the maximum number would be? I'd like to know what it is, if possible.
Well, I could answer that. You would have to know how each property had been on the market. I don't know that. And you could do it by 8 properties, meaning $8,000, and you could multiply that by the days that each property was on the market. So it's extremely high.
Steve, where Martha's going, if Anna could confirm that there were actually 8 homes for sale on a website by company, listed by with the company that wasn't licensed, if they didn't own any of those 8 homes, she could make the argument that the civil penalty could be as much as $1,000 times 8.
Or times 30 days.
If you could document that.
So I'm looking at the complaint file right now, and there are 8 properties that are listed in the complaint, but I'm not seeing 8 listings that are provided with the information provided in the file. I have a copy of 1 listing, but there are 8 properties that are listed.
There are 8 properties listed on that 1 listing.
So in the complaint summary information, they have written out the addresses for the properties, but they haven't provided the actual listings. So there are 8 named, but I only have a listing of 1. So I don't think that would be sufficient enough information for 8 specific violations, as we don't have those specific listings. We just have the 1.
Could you provide any other information about the let's call it the respondent, the respondent? Are he or she, are they sophisticated business people? Are they people that don't know what they're doing, or what are they, why are they doing this?
So it looks like they have a website, and they are not, it's 2 different individuals that do not have, they're not listed with our own, they're not licensed with us. So I think it looks like it could be a business company, but right now it just looks like unlicensed activity for.
I mean, were the properties $4 million houses? Were they $10,000? Were they what was the magnitude of the?
Right. So,
maybe it's in here. What was the?
So for the one.
Value?
For the 1 property that I have listed, it is a home that is valued about $1.4 million.
Holy smokes.
But I do not have information for the other 7. It looks like they have a technology background. That the individuals state that they're IT management professionals. But it also looks like they're listing homes as well.
So I guess my thought is more along the lines of what Marcia is that $1,000 is like a throwaway number, and we ought to really make a statement, that's my opinion, and up the number to something significant. And I don't know what that number is, but more than 1,000.
So they're looking at it as cost of doing business, in my opinion, Steve, $1,000. But Anna, what I'm thinking is that website still up? Can you look at their website and tell us how many are on their website today?
Sure. Hold on 1 second.
So I know we can't go over 8 because that's what this complaint is, even if she tells me there's 20. Correct?
No, no. I think if there are 20 and you think there's reason to believe there are 20, then you can make your decision based on 20.
Okay.
I think we're a commission. We can do what we want to up to a point.
Okay. And we have to realize too that the complainant is not a licensed person. They're just a Tennessee resident, and they don't know probably that they needed to send in a copy of all 8 of them. I'm sure they thought that we had investigators that would investigate their complaints. Which is another thing that the Real Estate Commission has no control over, is we're not in charge of the investigators or investigations.
That's mostly true, but we can send investigators out.
Yeah.
We just don't have any on our staff.
Mhm.
So I'm not able to pull up their website. It looks like it's been taken down. But the one listing that we have is on one of those larger third-party sites. I'm going to see if I can find information for that specific listing on if it's still up on the website.
Is anything closed, or is it just being marketed, or do we know that?
We don't know.
So if I can summarize, at this point, we only know of one possible violation. Just one.
I think we can make an argument. I think make an argument for 8 because they didn't respond. And I think the fact the allegation was made without a response is probable cause to believe it's true. And that's how I look at it. So I believe that, as Mr. Frank said, you could come for 8 unlicensed activity.
Okay, I'd like to make a motion then.
Chairman Grace, I just wanted to chime in. I have able to find their website, and they actually have 11 listings.
That's very helpful. Anna, Marcia, you want to make that motion out in light of that new number?
Yes, I would like to make a motion that we file a civil penalty of $11,000 against this respondent.
Steve Glenn, you're going to second that, right?
I was thinking of a higher number myself, but I'll
The problem
second
is
it.
we don't know how many days, Steve. If I knew how many days, I would up it.
Well, I mean, they're breaking the law, basically, are they not?
They're unlicensed activity, yes.
I don't even know what is there any way for us to file any kind of a lien so that we know we get the money if the house sells, or is that that's maybe more of a legal question.
We don't have that authority. We don't have
All
the
right.
authority to file.
All right. Okay. All right. I'll second.
Thank you, Steve. And the odds of receiving an agreement to this offer is fairly slim, I would think. But commissioners, on the floor is a motion made by Marcia Franks and seconded by Steve Glenn that this respondent offered a civil penalty of $11,000 for 11 cases of unlicensed activity. Is there discussion? I hear
John.
Yes. Yes.
Anna, will you put in that letter that it's $1,000 a day per property, so they know that there's I assume that if they continue to do it, that they'll be aware that there's more fines coming, type deal?
So in the consent order, we can place the language of the statute that says there's up to $1,000 per day for a penalty. I do not believe that we can have like an ongoing consent order, but if the individuals were to not sign the consent order and this were to go to hearing, that is definitely something that we can take into consideration in the future. But we will put down, we can make sure that that statutory language is included in the consent order.
This is a question, maybe for Mark. Is a civil penalty, what kind of form is it? Do you write them a letter? Is it return receipt requested? Is it, how is it delivered, and what kind of legal status? I mean, is it, it's not a misdemeanor. I mean, I'm kind of struggling for exactly what does it mean? Are they going to throw it in the trash can, or what happens?
Okay. First of all, we send two documents. We send what's called a 501c3 letter, which is a letter that is required under the Administrative Procedures Act, and that says this is what you have been alleged to have violated. The commission has met and believes that this should be litigated under the Uniform Procedures Act. If you want to settle this, you may do so under the, which then provides, in this case, the $11,000 civil penalty for having 11 properties listed and being unlicensed. If they ignore that, we do send it return receipt so that we do have evidence that it is, and then it proceeds to a administrative hearing. Now, this is all in civil. This is a civil action, so it's not a criminal action, which we can't enforce, but we can civilly. So if we have a hearing and, for example, they don't show up, and the commission and the administrative law judge determines that, whatever the civil penalty is, it becomes a final order after the judgment, after it's heard, and the matter is adjudicated, either in front of the commission or in front of an administrative law judge. At that time, it's sent to them and said, guess what? We got a judgment on you. And if you don't pay it, we're going to turn it over to the Attorney General's office for collection.
Got it. All right. Who signs the consent order? Do you or John? Who signs that?
The executive director, and the attorney for the commission.
Okay. Thank you.
Good question, Steve. Okay, the motion on the floor, if there's no other discussion, is to offer this respondent a civil penalty of $11,000.
And John,
Yes, Marcia.
John, and I'd also like to say to Steve and the others that in the event they choose to have an administrative hearing, if they don't agree to this consent order of $11,000 penalty, and we have the hearing, we do have the opportunity at that point of counting up how many days and increasing that penalty should they decide to go to an administrative hearing.
Does it say that in the letter that they get? In other words, they know on the front end that if they don't respond and they have to come to a hearing, that the likelihood of the number going up is high, or would it be a surprise to them?
I think
The settlement information is provided in a consent order in the cover letter, so the individual knows that this is for settlement purposes only, and that if they go to a hearing, they may be subject to further penalties. So that information
All right,
is provided.
Thank you.
Let me say this. We haven't had a hearing in a long time, but the commission should not go into a formal hearing with a baseline in mind. Okay, it starts all over at that point. And maybe we'll say there was something we've discovered that we didn't know before that caused us to dismiss, or it may cause us to offer more, but that's not the baseline we work from.
But we would have an opportunity to do some prep work before a hearing from our side, correct?
Well, at a formal hearing, the state will be represented by an attorney. The respondent likely will be represented by an attorney.
Right.
We make our decision based on the evidence that's presented that day. We don't, nothing in the past counts. We can ask questions to try to discover information. But we're a jury based on information presented to us.
But if
We're not investigators.
But if we had questions like, did it sell or not sell, or what county is it located in, or those kind of things, we should know that before we go in there, should we not?
No.
No.
No,
No?
so that information
No.
will be handled at the hearing. So you will, what happened, actually, since this is an unlicensed case, if it were to go to hearing, it would be an administrative law judge only. But typically in hearings where they're before the commission, if there are specific questions you have, you're hearing the case all over again, brand new. And the attorney, so I have a hearing that's set for September. So I'll present a case to you, and you, and then their opposing counsel or the respondent will also present their side, and then you can ask questions. So as Chairman Grease says, you sit as a jury. So you will be adjudicating the things that happened that day of.
So you're the one that's finding out all the information beforehand, correct?
Yes, me or the attorney that
Correct.
has a specific
All right, that's
that
good.
is
All right.
assigned. Yes.
So on that day, I can't go to, knowing who they are, because we don't know who they are at this point. I can't on that day open up my phone and go to Facebook and see how many days that's been on there. But I am able to ask our attorneys to look that up for us. So we can, through them, ask any question we want to ask.
Beforehand.
At the day of. Yes.
Let me say this. I hope we have a formal hearing in September, and I hope it's in person. But there will be a judge there that will instruct us on what we can and can't do. But as a jury, we go in clean. We don't take anything we think we know, or we thought we learned, or we remember reading about, and use it as a basis of our decision. It'll strictly be based on the evidence provided by the complainants, the state's attorney generally, and the respondent. And hopefully the respondent will have an attorney. Sometimes respondents like to represent themselves, and it's just not real smooth, typically. Okay, good questions, good discussion. We still have a
Thank you.
vote to take. Steve,
Pardon?
did you say something, Steve?
No, I said thank you.
Did you? Okay.
Yeah.
Okay, let's vote. The motion is to offer this respondent an $11,000 civil penalty. If you're in favor,
I don't think we ever got a second.
Yeah, we did. Steve,
I second.
It was my motion and Steve seconded.
I'm sorry.
okay, wait, that's okay. Caitlin, please call the roll.
Okay. Commissioner Joe Begley.
Yes.
I think we might have lost Commissioner Jeff Diaz. Vice Chair Marcia Franks.
Yes.
Commissioner Steve Gwynn.
Yes.
Commissioner John Moffett.
Yes.
Commissioner Stacy Torbett.
Yes.
And John Grease.
Yes. So that motion passes. We're on to case number 10. And again, using the same logic that we did in case number 9, I pulled this because I thought a failure to respond might be a more appropriate basis for a civil penalty, but I stand corrected on that at this point. So I'm going to suggest that somebody make a motion to approve council's recommendation on number 10.
So moved.
Second.
Ms. Franks makes the motion to approve council's recommendation. Ms. Torbett seconds that motion. Is there discussion? I hear none. Let's vote. Caitlin?
Hey, Commissioner Joe Begley. Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett, Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. So that motion passes. Number 16.
And Mr. Chairman,
Yes, sir.
I would like to change the recommendation on number 16.
Okay.
Having looked at that, I believe $500 for failure to disclose a personal interest is warranted under 62-13-4037B.
Is there a motion to accept council's recommendation?
So moved.
Thank you. Is there a second?
Second.
John Moffett, was that your second?
Yes.
Thank you. So the motion, if approved, would offer this respondent the opportunity to agree to a $500 civil penalty and have this case go away. If you're in favor of that motion, and the reason, just for purposes of the record, is council says, recommends this because the licensee did not recommend that she was related to a party she referred the complainant to. Let's vote, Caitlin. If you're in favor, vote yes. If you're opposed, vote no to accept council's recommendation.
Okay, Commissioner Joe Begley,
Yes.
Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn. Okay, I think, Steve, you're on mute.
Yes. Thank you.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. That motion passes. We're on to the last case that was pulled out, Ms. Franks, case 17.
So I was a little confused about this one. It said that the respondent did not provide a response and they were a licensed vacation lodging service in Tennessee. But then I saw in the records that they expired 1/25/2008 as a voluntary surrender. So I guess I need to know, number one, I guess, why are we hearing it if this person is not licensed? And number two, if they are licensed, then we need to get them for that they didn't respond. So I'd like Mark Green's direction on that.
I think they're not, but I do believe they are doing business in Tennessee. But it appears, Anna, could you open that file, please, and see what information we have? I think I might.
So it appears that the individual voluntarily surrendered their license, so it means they do not have a license right now. So if they're acting as a vacation lodging service, it would be treated as unlicensed activity. And as you know, we cannot penalize an individual for failure to respond if they're unlicensed.
Were they licensed at this?
Their license was voluntarily surrendered in 2018.
And
Yes,
this was
January.
opened in May of this year.
And it was opened in May 2020.
Yeah, Commissioner Franks, I would change my recommendation that they are for $1,000 for unlicensed activity.
And do we know it is that just that one property?
I believe that's all we have right at this moment.
Let me open
Has
the
something
file
is
really
good.
quickly. Let me consult the file and I'll get right back to you.
John, were those your same questions?
Yes.
On 17?
But however, I'd like to, this may be a case where an investigator might be appropriate. You know, there's a long history in the Smoky Mountains, so I don't know if that's where this took place, of people collecting money from prospective vacationers and then not returning money or not having a property available. In this case, here's what I know for sure. This entity surrendered their license, which causes me to think that they probably weren't doing the right thing to start with. And now they're back in business, and I don't know how much business they're into, but this would be one I would think we might want to send an investigator out to, just see what he or she can find.
That might be appropriate. And unless we have something in the file that may,
So according
and
to
I
the
apologize
file,
for not knowing that.
there's only one property listed in the file.
In the complaint, right?
Yes,
complaint.
yes. They don't have the information for any additional properties.
So then, John, could I make my motion to be that we send it out for investigation?
I'd be happy to defer it for 30 days. In the meantime, have an investigator go out and see what else he could find to help us with.
Okay,
Second.
Thank you, Steve. So the motion on the floor is to defer case 17 to our September meeting and request that an investigator take a look at this company or entity to see what we have. Further discussion? If not, Caitlin, will you call the roll, please?
Commissioner Joe Begley,
Yes.
Vice Chair Marcia Franks,
yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, that motion passed. We'll hear again next month. Okay, I think that's the end of the consent agenda and legal report. Mark, are you going to stay with us a little bit, or are you finished?
Absolutely.
Stay with
Absolutely.
us. Perfect. Anna, hearing schedule. You've already alluded to September.
Yes, I know that, I think Mark is going to speak more on it. I know I have a hearing set for September to be heard before the commission, and also a hearing that is scheduled to be set for November as well. I have one other outstanding notice of hearing and charges to file. We're trying to figure out to get more information about the hearing for our meeting in October, to figure out if that is going to be a traveling meeting or if not. Once we have that information, I'll have more information about formal hearings for October and also for our rulemaking hearings.
Okay, and for commissioners' benefit, assuming we meet in person in September and November, the formal hearing will be the second day of a 2-day meeting. Is that correct, Anna?
Even if it's not in person, it's going to be on the second day
Okay.
of the hearing. So let me triple check the dates we have. So September, the hearing is going to be scheduled. It's scheduled for the 10th. And the one in November is scheduled for November 13th.
Okay, so commissioners who've never been to a formal hearing, and most of us haven't, it's a 2-day meeting, either over the internet or in person, which I hope to heck it is. Okay, thank you, Anna. Mark, did you want to speak more to this formal hearing issue?
Well, talk more. I wanted to talk about what we're trying to do. First of all, Pam Spicer is on the line. She's our chief counsel, and Pam has been tasked by our general counsel, John Spear, of reducing caseloads and moving cases across the board, not just for TREC, but for all programs. And so in a minute, I'm going to ask her to talk about some of the things she's doing about moving old cases, getting those matters taken care of, and also setting for hearings. I do want to go ahead and say, and I told Caitlin last week, this is not an excuse, and I don't want to lead anybody to believe that anything I'm saying is me excusing. We currently are down one person in track. That person would normally be a disciplinary counsel, dispute resolution counsel, somebody that would set hearings. We had, as you remember, Kelsey and Kristen for a while, and my intent in the summer, or not in the summer, but in the spring, was to move Dennis Gregory, who is an experienced litigator, back over to Trek to work with Kristen and try to get more cases set. And then Dennis got military orders and is now in Kuwait. And he's our second attorney right now that is over in Kuwait on military orders. So obviously we are down. The pandemic slowed us down as far as hiring. And obviously switching everything to online has been a difficult position. We currently are working on training with the Administrative Procedures Division, not only training for us, but training for the commission and the boards to do training for formal hearings in case they are online going forward for an unforeseen time. So we are trying to address the fact that we are A, short an attorney, and B, needing training as far as knowing how to do formal hearings via the WebEx or the Zoom or whatever the application may be. So I'm going to have Pam kind of talk over some things about what we're doing on the litigation side, and try to and get her to explain what she's working on.
Hey, Mark.
Yes.
Before you do that, so we got new commissioners. Would you tell us how Pam fits into the hierarchy of the legal?
Sure, I'd be happy to. Okay. The commissioner hires a general counsel, and the general counsel is in charge of both the commerce side, which is where we fall, and the insurance side, which is where obviously insurance, securities, fire protection, TennCare oversight falls. So the general counsel is the legal advisor for all of those areas. He has that's John Spear currently in the general counsel position. He has two deputy general counsels. I'm the one that's over the regulatory board's side, and Malika Bass is the one that's over the insurance, securities administration, all those other insurance-related side. I have two chief counsels, one of which is Tony Glandorf, who's one of the other attorneys who is in Kuwait right now, and the other, Pam Spicer, who's been a chief counsel since, I think, January. I may be wrong. January, I think. And they, the regulatory board's programs, boards and commissions, not programs is really not really the right word, but boards, commissions, and the commissioner run licensing programs. And so they have about 8 to 10 each. They have responsibilities for not only advisory services, but also the disciplinary counsel who manage dispute resolution. So they both answer to me, and then they have 8, 9 attorneys and paralegals that answer to them. Pam is the chief counsel. She works for me as Tony Glandorf does, and then she has her attorneys and paralegals that.
Thank you. I appreciate that. Pam, can you join us?
Yes, I'm here.
I don't see you.
Oh.
There you are.
I see myself.
Now I do. Okay.
How are you?
We're good, thank you.
First, I wanted to speak to something that Mark just mentioned about the Administrative Procedures Division offering training to the boards and commissions for hearings, since the new normal is that some of these hearings may be virtual until we get back to in-person hearings. Caitlin had asked me to get some dates for you all for this training. The training will only take about an hour, and the training is conducted actually by the Administrative Procedures Division, coordinated through their executive director. So I have some dates if you all want to discuss those dates now, or would you rather Caitlin circulate those after the meeting?
Let's let Caitlin circulate them.
Okay. Because I know that Anna has a hearing coming up on the 10th. And if possible, if you all would like to have the training before the 10th, we can try to make that happen.
So this is in person? This is in person, or this is remotely?
The training or the hearing?
The training.
The training would definitely be remotely.
Okay.
And Anna, as far as you know right now, is your hearing remote?
So the
do we
order
know
that I got from the judge has it in person. But
Good.
if anything should change, such as an executive order or anything, we'll be having it virtually. So this is just based on the information that we have now. So it can go either way, depends on what we get.
Right. And Marcia, to answer your question, though, the training would be remotely. You would all be asked to join probably a Zoom or a WebEx for 1 hour for a discussion with persons from the Administrative Procedures Division who conduct the training. They kind of outline how the hearings are going remotely, what to expect, how the exhibits are facilitated, kind of how you go about not talking over each other when you have questions, and then kind of what's expected from the judge versus you all as far as everyone being online and on a video.
I was just talking away. Just a couple, we need your video on at all times since this is being recorded for Chuck. That is one of their rules. So see back screen video off. Any other questions from anyone?
I can't understand what you're saying.
Okay, can you review, because the scans, you said that the one that you could put it in a PDF and put it on your phone or iPad, which one did you like that did that?
Well, so if you have an iPhone,
I think we're getting feedback from somewhere else.
I think this is, yeah.
iPhone, it actually has a PDF.
Hold on.
Let's take Donna Wood off.
Down at the bottom, if you click on the camera, it'll say scan documents, take photo for video, or photo library.
Todd, can you mute Donna Wood, please?
And you can
Thank you.
Okay. Before I got totally confused, we were talking about training online. And at this moment, our September hearing is scheduled to be in person. However, Anna said it could be changed at any moment, so be prepared for either. Pam, are you still there?
I am. And all of what you said is correct. So I just wanted to let you all know that this training is available if you all are interested. I can circulate the dates through Caitlin, and then she can let me know, and I'll coordinate with the APD to get that set up.
Anything else, Pam?
No, that's all. That was the main thing I wanted to let you all know.
Can I make a general comment, not directed at you, Anna, Mark, anybody? But sometimes I kind of feel like TREC might be considered a stepchild in the sense that you don't give Anna enough help. We hadn't had a formal hearing in forever. And what I think about with formal hearings, there are members of the public generally who filed a complaint or responding to a complaint who would like some resolution. And yet we can find some guy, offer some guy a civil penalty or some girl a civil penalty, and they refuse to accept it. And so far, it appears like they can go on for a year or more without having to actually defend themselves or explain themselves. So I hope we can get back to where we can facilitate these contested cases quicker. I know that's what Pam's supposed to do, and Mark, I know you want to say something, so please go ahead.
I just want to say that I agree we need to have more formal hearings. And I assure you that at no time is TREC ever considered a stepchild in the regulatory board's division. TREC is one of the high volume complaints, one of the definite areas that we all pay attention to. It is very important to us. It's not only important to us, but we know it's important to the legislature. So we always try to do what we can in support of TREC. And I want to make that, and I just want to make that statement as clear as I can. We understand that we are short-staffed right now, and that we are attempting to work through that. As far as formal hearings, we need to have more formal hearings, absolutely. But we are resolving cases, and just because we don't have that we get to the point where we almost have a formal hearing and the matter settles. So we do attempt to and do succeed in getting many of those cases resolved. You may not always see that, and that's why I think it's important to have formal hearings so that you do get the resolution in some of these matters, and we are working on it. One other thing that we have really made inroads in is 5 years ago, we had cases that were 800-900 days old. We have worked diligently in that time to reduce those to now what we consider an old case is a case that's reaching 300 days old, which is less than a year. So we are working on it. We do need to have more formal hearings. I say that again, but we are working on reducing caseloads and resolving cases that not only in TREC but across the board. So I take your comments seriously. We are going to ensure that we do get more formal hearings before the board and get this position that we have now filled. Anna does a great job with not only TREC but all of the programs that she works with, and I just we are working for you. That's what I wanted to say.
So, Mark, I appreciate your comments. Let me just, and I know you're not taking it personally, and I'm not taking it personally, but one more thing about the complaint process and formal hearings. They're a great training tool for licensees. Licensees pay attention to what type of discipline the commission imposes and what they impose that discipline for. So the more visible we can be to licensees and the more current we can be with licensees, I think the more we help serve the public. I'm done.
I got a
okay. I wanted to say, I'm sorry.
Go ahead.
Mr. Chairman, I got a couple of questions, if I could.
Sure.
While we're talking about this, do y'all, Mark, do y'all track like how much time you're spending or on these cases? Would you have a guesstimate as to, like, we see the consent agenda and it's got, I don't know, 70 cases on it. It's pretty voluminous. What's approximately, or do y'all track that, or how does that work? And then the second question I have is, I've noticed from time to time there are cases that say anonymous, and I'm wondering, do we just take a call from people that don't identify themselves, or is that the regulations say that you don't have to identify yourself, or what's, and maybe that's too much detail to talk about now, but and maybe it's going to come out in the training that I'm looking forward to Pam doing, but I'm just curious as kind of how this is all working, because it seems to be a lot of work for something that many people have no case, and you know, it's who shot John kind of stuff, and just a lot of information that seems to, I'm just curious.
Let me answer your second question first by asking Anna, who has some insight on anonymous complaints. And Anna, would you like to answer the commissioner's question on anonymous complaints?
Sure. So the complaints that we receive, sometimes we have individuals that provide their name and information, but sometimes the individual is just listed as anonymous. You're not required to provide your information to us when you file a complaint, but always information is very helpful, so we can contact the person if we have any follow-up questions. So it's not receive anonymous complaints in the form of phone calls. We receive them in our online complaint forms. Also, we receive them sometimes via mail as a written complaint from an individual, and we process those as normal as usual. We look to see if there are any violations for the complaint. It's processed and sent out for response. So it's not required that the individual provide us their information.
Okay.
But we do make a preliminary check to make sure that the information falls under the jurisdiction of the Real Estate Commission. So if someone were to file a complaint against another individual that get lots of complaints, for example, that deal with landlord-tenant issues, those complaints are not going to come before the commission, because the Real Estate Commission does not have jurisdiction over landlord-tenant issues. So the complaints that you see before you that are anonymous are issues that most likely fall under the jurisdiction of the Real Estate Commission.
Okay. Thank you very much. I just have a basic problem with people that are complaining that don't want to identify themselves. Whether it's, I don't like my hamburger at McDonald's or whatever it is. That's just, you know, it just seems to be basic that a person, but I'm not going to, that's enough said.
As to your first question, we track we don't call it bill or hours per program. And so we don't, every week our attorneys in every area turn their numbers, turn their hours in that they spent on that program. And so a disciplinary counsel who prepares the legal report, it won't necessarily, 20 hour report, but it would say 20 hours with TREC. And because they're a disciplinary counsel, that's, they're either working on a case or they're working on the legal report. So that does that answer your question,
yes,
Commissioner?
That does. Thank you.
And Mr. Chairman, I've got one more thing. Our general counsel is very involved, and in fact, he's online right now. I just saw, and in wanting to staff up for TREC, he is very involved in that. We have discussions about it. He is very involved right now. The positions are frozen, and our general counsel is working to get those unfrozen, and it's frozen due to budgetary constraints under the current pandemic situations. So the commissioner, the general counsel is working with the commissioner's office to get those two positions actually unfrozen as critical mission operating positions. So he's very involved in wanting to make sure that we are fully staffed for Trek and doing everything we can in order to do that. So I wanted to make sure that you understood it was even above my level.
Got it. Thank you, Mark. Any other questions for Mark, Anna, Pam? I don't want to bring John Spear in on it right now because Steve Gwynn might have something he wants to say to him. So I'll leave that alone. Okay, if not, let's go to Mark. We're going to get out of legal now. You stay with us if you want to, but we're going to talk about remote classroom course request. Caitlin.
Yes. In your email with all of your meeting documents, you would have received 2 requests in regards to the remote classroom courses that are currently extended through the end of the year. This request is to extend that allowance even further. And so since the request was geared towards the commission, I wanted to make sure that those were presented to you. But currently, classroom courses are allowed to be offered via remote means through the end of the year.
And so, okay, so you're being encouraged to encourage commission to extend that through some period of 2021.
Yes.
And what are your initial thoughts on that, Caitlin?
My initial thoughts are that it's not a bad thing. I personally don't know that we'll be meeting in a 50-person classroom come January. I would like for myself and our legal counsel to be able to review this further as far as what is kind of a more permanent solution, what our statute allows for and what our rules allow for, and where this really falls. If this falls under a statute change, a rule change, or if it's something that without an executive order, the commission has the authority to allow. I don't think right now we fully know where the change to make it more permanent would fall.
So if it was up to you, you'd put this off for a month or 2 while you checked with counsel to see what we can and can't do.
I don't think that would be a bad idea. I think it's been a very good thing in the interim. I think we have seen a lot of providers be able to continue business and students be able to continue learning and doing continued education. So I think it's a benefit to everyone, but I think we do need to look at it in a more permanent capacity and determine, what that looks like.
So based on what Caitlin just said, is there any objection to putting this off for a month or 2 while they study it further? Marcia?
I would just like to say this, that I am wholeheartedly behind this as a licensee myself, as a principal broker. I'm hearing from other licensees how much this has benefited them. I really don't see any negative to it at all. I think our focus should be on our licensees having available to them classes and learning and continuing education in any form that we can get it to them, because we want them to take the classes. And if they will take something sitting in their home, and maybe they're, at an age where getting out is not a good thing at this point, or even into the future. it makes it easier for our licensees. It also protects the public, and that's what we take an oath to do, is protect the public. The more that we can get our licensees educated, the better the public's going to be. We still have several people who are grandfathered, brokers that are grandfathered since 2005. And, any way that we can get those people to take classes, if they would do it in their homes or their offices, so much better. And when I made the motion that we extended until December of this year, I knew then it was my full intention to encourage that we take that to a much longer date than just the end of this year. I know that they have to set up their speakers and their teachers a year in advance. So everybody's just standing on standby right now, not knowing what they can do in 2020. So I think it's very important that we be able to allow these classes to be done virtually, whether we like it or not. We are in virtual world now. I see in the future us continuing to do business remotely, and to say that no, you got to go sit in a classroom, that's so out of touch and out of date that we just can't simply think that's the way it is anymore. And I can tell you that all states are going this direction. It's not just Tennessee.
Marcia, I think everybody agrees with you. I think what Caitlin wants to do is be able to show the statute or the rule that allows us to extend it without changing a statute or rule. That's what I think they need a little time to take a look at.
And I'm perfectly fine with that, because I want this to be very transparent, and we need to do that step regardless. I just wanted to give you my opinion and to let Caitlin know how this is not, as a licensee, I am a licensee and she and our attorneys are not, that this is very important to licensees. And I'm just speaking on behalf of them.
Understood. Caitlin, is it something you can bring back to us next month?
I think so, yes. And I agree with Marcia. I definitely see the benefit to it for the student and the provider. And I really see no negative in it. I just want to make sure we're doing the correct thing on our end as we move forward, as far as the laws and the rules go.
Okay, other comments? Okay, according to my agenda, we have one more topic to cover quickly, the 2021 meeting calendar. It was emailed to you at least once, and that was last week sometime. I have one comment. If everybody has that exhibit.
I believe I can put it on the screen as
good.
well.
Wow. Perfect.
Can you see it?
Yes.
Okay.
So November 2021.
Mm-hmm.
Wednesday, November 10th, and Thursday, November 11th. Well, come to find out, Caitlin has informed me that Thursday, November 11th is a state holiday. And I'm not sure why. I didn't think about this to start with, but I think Wednesday, November 3rd, and Thursday, November 4th, would give us the opportunity to have a two-day meeting if we needed it. So that's just a comment, but my preference would be to plug in the 3rd and the 4th of November.
And I will not be here then.
What do you have?
Well, I may be going out of the country.
Oh, okay. I thought it was a Rello. I'm sorry. Because we looked up a Rello schedule.
Yeah.
It's good you're planning that far out. I like that.
I have a question, John.
Go ahead.
In October, that's an East Tennessee meeting.
Yeah. Yes.
I'm usually gone that week about annually. Is there any way that can go forward or back? I don't even know what we're supposed to be doing here. Are we supposed to be commenting on this or just
Yeah.
here?
If you like the next week after that, let's see what other people think.
Unless that's a huge problem for people. That's my
we will-
wife's fall break as a teacher, and we usually go to.
It's everybody's fall break.
So it
There you
is.
go. So what if we looked at the 15th and 16th, Joe?
Perfect.
That's a Friday and Saturday.
It would be the 14th and 15th.
That's my fault. Now, the only problem with that is we meet again in 2.5 weeks if we go to November 3rd and 4th.
Yeah. Okay.
I mean, we could stick with November 10th and just have a one-day meeting, know that going in.
I'm flexible. I just may not be there.
Yeah. We're going to all miss at some point, probably.
I just didn't want to miss the meeting in my hometown.
Oh, yes.
Y'all don't,
Yes.
I mean, if I was going to host it.
So in that case,
At Stacy's house.
Assuming it's going to be up there in Upper East Tennessee, because somebody has to make a proposal to us, but listen, you want to stick with the 14th and 15th of October and the 10th of November with a one-day meeting?
Legal, do you have any concerns about just doing the one day in November?
No, I don't have any concerns. We can make sure to adjust the schedule accordingly so that we can accommodate that one-day meeting.
So I'm gonna change that to one day and then change.
Hey, Joe, let me say one more thing. So we've traditionally done it on a Thursday and a Friday, but there's no requirement we do it on a Thursday and a Friday. So if you thought Tuesday and Wednesday would work better,
that would be
or if any
perfect.
commissioner thinks that, we can do that. We don't have to go Thursday, Friday.
We mostly did it in East Tennessee and West Tennessee, those meetings where if we do them on Thursday and Friday, if those who are traveling can stay and enjoy the color in East Tennessee, or is the reason that we've done it that way in the past.
But at the moment, I'm going to say it looks like October 14th, 15th.
Mm-hmm.
And November looks like a one-day meeting. November 10th. Other comments? The reason we like to do this early is because there's always some demand for the meeting rooms. And the quicker we can get on the schedule, the more we shut other people out from having those meeting rooms. Okay, is there a motion to adopt this calendar as amended, as is in front of you at this point?
So move.
Thank you. Is there a second? Thank you, Stacy. So the motion is to approve this calendar. If you're in favor of the motion, you'll vote yes when Caitlin calls your name. Caitlin.
Okay. Commissioner Joe Begley,
Yes.
Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes.
I
And
can
by
get
the way,
updated calendar sent to everyone with the dates decided.
perfect. And Joe, if you find out your wife's fall break is a week later, we'll move it back. We've got flexibility with the schedule. Okay.
John?
Yes, ma'am.
On that note, I wanted to ask that since we did not have the May meeting in West Tennessee, I'm just wanting to make sure, I mean, statute says that we have one meeting in East Tennessee and one meeting in West Tennessee per year. It doesn't tell us what month, but it does say that we have it. I'm just wanting to make sure that we're cool, that, you know, we did not have the May meeting, or are we going to be going to West Tennessee, or what's the status of that? Is that a legal question?
I'll give you my opinion. I think the governor gave us a lot of latitude not to go to East Tennessee, not to go to West Tennessee. I think we're okay.
Okay.
We're still on the books to go to Chattanooga in October. That may be 50-50 at best. But I think the governor and his executive orders might dictate what we can or can't do. Caitlin, what do you think?
I think that's fair. So I think depending on what happens with continued executive orders on meeting in person will dictate future meetings.
Right. Any other business to come before the commission? If not, let's see if anybody has any closing comments. Stacy, any closing comments?
No.
Thank you, Joe.
No.
John Moffett.
No. No.
DJ, are you still on there?
I'm here. Can you hear me?
Yeah. Anything you want to say on the way out the door?
I'm excited on participating more actively next month, and the next 5 years, I bet that I will miss a November meeting as my anniversary is November 10th. But
Bring your wife.
To be with my wife.
Bring your wife to the meeting.
I really am impressed by each of your contribution. Anna, thank you, and Mark and Caitlin for helping me get on board this week. Really feel like y'all are giving us your full attention. So thank you, and Chairman and Vice Chairman for reaching out. Joan reached out earlier this week, and appreciate you all for the welcome, and look forward to more time with you. Thank you.
Perfect. Thanks, DJ. We're looking forward to seeing you. Steve.
I'm good. Thank you.
I've got a question for you.
Yes, sir.
It's none of my business, but there's a portrait behind your silhouette.
Yes.
Who's in that picture?
That's my wife and five grandchildren.
Beautiful.
And I've got one grandchild on the way in November, so it'd be 6, and I think that's going to be the end of it. So anyway,
You're not in charge of that.
Huh?
You're not in charge of that.
I'm not in charge of that. You're right, but I know my daughter, and anyway. Oh, I'll say one other thing, John.
Yes.
I don't know about the West Tennessee meeting in 2021. If Jackson is going to want to have it, since they didn't have it in 2020, but I'd volunteer Memphis to host it in 2021, and I'll even throw in some entertainment into the hopper. And I'm in a big band, and so we could have a little party and play for everybody.
Oh, wow.
Steve, you do recognize that Trek has no money to spend for entertainment.
Lamar does, though.
Okay.
Well, I'll make you a hot deal.
Okay, we're looking forward to it.
I'm in charge of the bookings.
Thank you, Steve. Hey, Marcia.
Yes.
Before your final comments, let's talk about that portrait behind you.
Okay,
Who do
okay.
we have?
That's my husband and I and our two daughters several years ago, and a little kitten named Lucky that only lived about 2 weeks, just long enough for the portrait.
Well, beautiful family.
Thank you. Thank you. Yeah, I wanted to comment about Bobby Wood. Bobby Wood term expired. And I just want to say how much I miss him and all of his sage advice. Such a smart guy. He was always so faithful to come to everything that we did. And I just want to say I'm really going to miss him, and I wish him well. But I'm very thankful that we had him for the 5 years that we did, because he was just an excellent commissioner. And I also want to welcome DJ, and to say to anybody new, if there's any questions, we're not just commissioners together, but we really become friends. And I look forward to knowing everybody better and having a relationship with everyone as we go forward. And welcome to DJ, and thank you to Mark Green for being in our meeting today too.
Good comments, Marcia. Thank you. I just have one question for Caitlin. Well, we'll end this meeting. Hey, Caitlin.
Yes,
How's the staff?
the staff is great. Everyone is, I think, thankful to be able to work from home during this time. But pretty much has been business as usual. So
Everybody's healthy.
everyone's healthy, yes. Mhm.
Perfect. Well, thank them on our behalf for the job they do. Thank you, Anna and Mark.
Chairman Grace?
Yes, Anna.
I believe we have one more additional question from Pam.
Okay, Pam.
Hey, John, sorry.
Hey, that's okay.
I thought of something when we were discussing the litigation, since Anna has some hearings coming up. Is the commission okay or opposed to having more than one case heard, at a time? If Anna already has a case set, because we would need to probably know that on the front end, because when we file the notice of hearing and charges, of course, we set the date.
So the great unknown is how long a case takes. And,
Correct.
And maybe legal can look at a case and say, this is going to take 2 hours. And if they feel comfortable with that, scheduling that 2-hour session in the afternoon, I don't think we're opposed to it. But all I know is nobody's going to be paying attorneys to sit around waiting for the first case to end, which I've always thought was problematic. But if these are smaller cases, minor cases, we'd certainly consider it.
Okay.
Especially get caught up.
Right, and we can look through those, and I can get with Anna to see how long she anticipates her cases taking, and we'll, if we think we can set more than one on a day, we will.
But remember, Pam, the second day is our getaway day. So I don't think any of us want to work till 6 o'clock on the second day and then try to decide how to drive home.
I understand.
Okay. All right, commissioners, thanks for your
Thank
attention. I hope you have a great week, and I hope you get to go do something you want to do. Take care. Bye-bye.
That's everyone.
See ya.
Bye, everyone. Take care.